Okay, pause right there. Before the judge even speaks, remember this: we're about to watch a man who shot his own father, violated probation twice, and still asked for another chance. If you've ever wondered how far mercy can stretch in a Texas courtroom, buckle up.
Are you Eric Deshawn Busby, sir?
Yes, sir. Yes, sir.
Present with your attorney. There are 3 cases, and these are motions to revoke unadjudicated probation. Then there's, which is a 3rd degree assault, family violence. You're on aggravated assault. All right. Then the motion has allegation number 1 of, I guess, the indictment. All right. So he's on 2 aggravated assaults, 1st degree felony offenses.
One is 2nd degree assault. You had it amended on the one that he went to trial on. 7-6, I believe.
There's one 10 over 10, so it can't be. How in the world did I get 10 over 10 on a
He
assault?
went to a jury trial on the first.
Oh, is that what it was?
He got 10 years and they recommended probation apparently.
Okay.
And then he came back several months later and pled to his second
This motion
case,
to revoke.
10 deferred.
And then now we have a new indictment. So what are we doing on all of this?
The state's recommendation is a 10-year cap, and what we are hoping is when we have a chance to explain to the judge, he is basically, the bottom line is he's wanting to see if the court will give him alcohol treatment through safety as a condition of probation, because this new case arose out of a situation that was laden with alcohol, and he has an alcohol problem. He did well, I believe, for some time. Is that correct? And then he's really wanting to go to safety.
Well, the big problem with that one is one of the conditions of probation he was on is to abstain from all alcohol.
Absolutely.
That wasn't even used in a motion to revoke any of this, and that's the basis of the problem.
That's the basis of his problem.
Was a probationary term.
Here's where the irony hits hard. One of his main probation terms was to stay away from alcohol. But the new charges? You guessed it, fueled by drinking. In legal terms, this isn't just a violation, it's a flashing neon sign that says, "I didn't learn my lesson." Judges hate that.
That he failed on.
Yes, sir. He has a problem with the alcohol.
It should have been addressed in 2019, 5 years ago. Now it's a problem.
He's just asking for help.
We got help in 2019. Is that what y'all want to do? Come to me on that? I just want to know, was that what the plan is?
That was what our plan was.
He's going to plead unagreed here, and then there's a cap of 10 years.
We had an agreement and everything running concurrent. He's already got the.
Are you Eric? You're Eric Deshawn Busby Jr.?
Yes.
Raise your right hand. Lower your hand. There are 2 motions to revoke unadjudicated probation. In summary, these allege that on July 25th, 2019 in 29176 and on or about October 28th, 2019 in 29177, in 29176, you were sentenced to 10 years in prison, probated for 10 years for aggravated assault. And in 29177, on October 28, 2019, you were placed on 10 years deferred or unadjudicated probation for the 1st degree felony of aggravated assault. Both these are 1st degree felonies, correct?
Well, one of them on the district clerk's website, the case that he went to trial on, there was an amendment in handwriting, I believe, with the judge's initials that said
It looks like that was 2nd degree. 29176 was a 2nd degree felony, so this motion to revoke needs to be corrected for second, correct, everybody? That is corrected. So it is a 2nd degree felony, and these motions go on to allege, first of all, is that true? You were placed on 10 years confinement, probated for 10 years for the 2nd degree felony of aggravated assault on July 25th, 2019 in this court in 29176.
Yes.
10 years deferred or unadjudicated probation on October 28, 2019 for the first degree felony of aggravated assault. Is that true?
Yes, sir.
And in each case, allegation 1 alleges that you committed the offense of assault, family violence by impeding breath or circulation on or about December 1st, 2023 in Jefferson County, Texas, which is indicated and is part of this new indictment allegation, ended up on January 25th, 2024 in cause number 24-CR60. Is that all true?
Yes, sir.
The your probations can be revoked and you can be sentenced to the full range of punishment, which is no less than 2, no more than 10 years confinement in 29176, no less than 2, no more than 20 years confinement in prison.
Your Honor, I missed what you said on the first one. Did you say no more than 10 years on the first one? The
No
second
more than
degree
2.
felony?
I think I said no more than 2, no less than 2, no more than 10 years confinement.
Yes, sir.
No less than 2, no more than 20 years confinement on 29177.
Wait,
It's that's a first degree felony. Isn't it?
okay, the first degree on 77 would be the no less than 5, no more than 99 or life. But then on the one that ends with 76, because it was amended to a second, and then he got 10 years, it'd be correct to no less than 2, no more than 10. So 2 to 10 on one, 5 to 99 on the other. Both of them with an agreement for a 10-year cap.
That's right. The first degree felony and 29177, that punishment range, to clarify, is no less than 5 nor more than 99 years confinement or life in prison. So it's two very serious punishment ranges. Knowing all of that, do you insist on pleading true to allegation number 1? The committing the offense of assault, family violence by impeding breath or circulation on or about December 1st, 2023.
Yes, sir.
In these 2 motions to revoke probation, there is no agreement.
There is an agreement for a 10-year cap and that they already concurred.
That's true, Judge.
Well, we would be asking to remain on probation with safety as a condition for our alternate.
The agreements I'm looking at, punishment will not exceed a cap of 10 years in prison on each case.
Yes, sir.
I'm going to follow these agreements. So you're looking at, once again, no less than 2 nor more than 10 years confinement, no less than 5 nor more than 10 years confinement in prison in each case. We can continue you on probation in each case, and I don't think there's another option because you're already on deferred or unadjudicated probation, and you can't convert that to that aggravated assault to a regular probation. So do you understand your options there?
Yes, sir.
It's just making sure you understand the difference.
Because we're about to go into, I'm going to make the decision on your life.
Yes, sir.
Go ahead.
And that's what we are asking. He says that he does have a problem with alcohol, and it was the underlying issue behind that allegation number 1 in the motions to revoke. He recognizes he has a problem with alcohol. I don't know when it began. I don't know that he's ignored it over the period of probation. I don't show where there's any major complaints about him since he got probation in 2019, I believe 2019. There may be some issues he had along the way, but nothing seems to have risen to the level to have a hearing before this court. And now 4 years have passed and he is still on that probation, and he did commit this assault. But he recognizes that he was out of control under the influence of alcohol, and he is begging, actually, the way he sounded when he was asking me about it, the court to give him an opportunity to get treatment that he knows that people tell themselves, I can do it myself, but
That moment right there, that's raw. You can feel the regret. But here's the big question, is remorse real when it only shows up after another assault? What do you think, should addiction excuse violence, or is it just another sad justification we've heard too many times?
He just hasn't been able to, and he's asking for help. Is there anything you would like to add?
Yes, I came here today with no excuses. And, I should have reached out for help a long time ago, but I didn't.
Can you put
And most people pray to God to get them out of serious situation, but I pray to him to have me sit down and get the help I need. So I'm sorry for wasting everybody's time, my family, the courts. I'm just asking that y'all give me another chance to help me finally turn my life around.
What's that?
Unfortunately, I did not try this case when it went in front of a jury. I've tendered the court the PSI on that. And the reason why I say it's unfortunate is because reading through the facts, I cannot for the life of me figure out why a jury gave this man probation. The facts of that are...
Boom. That's the prosecutor basically calling out the jury's decision on record. Remember, juries can recommend probation even in violent cases if they believe in rehabilitation. But this? 2 aggravated assaults, both with a firearm? It's one of those courtroom calls that makes you question the system's faith in second chances.
2 aggravated assaults involving family violence where he goes in and he shoots up 2 different people. The end result is one's a second degree because it doesn't result in serious bodily injury, and the other is a first degree because it is. What the state did was honor what a jury decided in giving this man a second chance. They chose to give him deferred probation on the first degree felony, and I don't fault them for that. I just, not having heard the facts, Judge, which you did, I'm going to rely upon your memory of those facts. What is very disappointing is that here we stand with the same kind of offense happening again, and what we're given are excuses. I don't abide by that. I don't feel like this man deserves another opportunity to harm another individual. The facts where this happened, this lady did not see that he was going to strangle her and potentially take her life. As Your Honor so eloquently says so many times when an individual stands before you, there's only one reason why you put your hands around somebody else's neck, and that is to take their life.
Squeeze.
So, Judge, I passionately ask that you give this man 10 years.
Go ahead.
And again, we're asking that the court, keep him on probation. Like I said, I don't believe that there are a lot of any really major issues he's had until now. He really is asking for the help. But if the court should decide not to, we would ask for the court to consider resentencing the first case that is the straight probation to 5 years and to run it concurrently with a 5-year sentence on the deferred.
All right. From probation, anything else?
Oh, no, I just would say that he was granted probation in July of 2019. He was given 180 days up front. In May of 2021, it was the same type of assault that got him a motion to revoke. He was dismissed, so we did 15 days jail time because of curfew violation, I think, and then we are here again. But prior to, he was reporting and attempting to pay fees. And as far as the alcohol goes, he never reached out for help. I did do UAs on him, and he was clean from our UAs.
Fine. Anything else? By anybody?
No.
This, on the aggravated assaults here, that you were placed on probation for in the first place. One of these victims, you shot your father, correct? You almost killed your father.
That's correct, Judge.
That's still not showing up.
So you were placed on probation, and the court would know on the probation review, you had been convicted of public intoxication back in 2017. So this problem goes on, has a history. You were given credit for time served. And then on the probation orders. One of the probation orders, number 11, do not become intoxicated or be under the influence of any intoxicating substance, which you claim now are the some kind, it may be the root of the problem or not. So you were placed on probation in these two cases, and thereafter, this new indictment comes along in December of last year, a few months ago. And this is another assault.
That's fine. That's something that was crazy.
So we've had to deal with this issue of family assaults and drinking irresponsibly since you were placed on probation, and it failed. The probation and supervision failed because of the choices you make. And this court's in a pretty bad spot now because of what you have done. And your attorney has fashioned a deal where in this 29177, you're facing up to life imprisonment. And somehow she was able to work that in an agreement to no more than 10 years, from life to no more than 10 years, or squeezing somebody's neck, choking someone after you've shot two, right? So this court is going to make the following findings in these motions to revoke probation in each of these two cases, 29176, 29177. The defendant has pleaded true to allegation 1, committing the offense of assault, family violence by impeding circulation and breath, has pleaded true voluntarily, knowingly, intelligently. Probations are hereby revoked. In 29176, your probation is hereby revoked. You were sentenced to 10 years in prison, probated for 10 years, and your probation is revoked. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time served. The judgment shall reflect that a deadly weapon was used in the commission of the offense, namely a firearm. In 29177, the probation is hereby revoked. Earlier, you pleaded guilty voluntarily in this case to a first-degree felony of aggravated assault, family violence, and using a deadly weapon, namely a firearm. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted during the course of your earlier plea. I now find you guilty beyond a reasonable doubt and that you have violated your probation terms by committing another assault, family violence. Your probation is hereby revoked. You are hereby found guilty beyond a reasonable doubt of this first-degree felony and hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. These two sentences shall run concurrently. Those are those. Now, what do we do in 24 CR 60? All right, 24 CR 60 is now called. Eric Deshawn Busby Jr. is before the court. In summary, this indictment alleges that on or about December 1st, 2023 in Jefferson County, Texas, you committed the third-degree felony of assault, family violence by impeding breath or circulation, by squeezing the neck. And does the defendant understand that this is a third-degree felony? Yes, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes. The agreement's been reached. Whatever punishment shall not exceed a cap of 10 years. And most importantly, whatever sentence shall run concurrently with these other two sentences. Is that your understanding of the plan? Yes, sir. If I follow this, you have no right of appeal. Yes, sir. How do you plead to this indictment? Guilty or not guilty, sir? Are you pleading guilty voluntarily and because you are guilty? Sentence report is hereby waived.
Yes, but I would like to request that the court consider that this case does not have a deadly weapon, and although committed while on probation, we would ask the court, and he has just a little bit of time toward it, we would ask the court to consider 5 years on this third-degree felony.
What's that sentence?
No, the agreement that was entered between the parties is that the time would all run concurrent.
Yeah.
And it capped at 10, so I'm standing by that and asking for the 10-year sentence.
Wow. Anything else to say, sir? All right. Then I hereby find you guilty beyond a reasonable doubt out of this third-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. This sentence shall run concurrently with all other sentences. This also shall reflect that this is a crime, another assault, family violence. The problem on this one, it makes it even more serious, is that you were put on notice that we treat aggravated assault seriously. So you committed another assault, another family violence after you shot your father earlier. Then we come back and while on probation, this is a dating relationship that you have. It's dangerous to be a family member of yours because of you. I mean, families.
Listen closely here, this is more than sentencing. This is a judge turning into a moral mirror. Family violence cases always hit harder because they betray the very bond meant to protect. So ask yourself, when mercy fails, does justice have to step in with both feet?
Is a blessing. I mean, it's supposed to be love, compassion, blood relationship makes it a special bond. The question then becomes really is, if you're going to treat family members that you're supposed to love like this, what would you do to some stranger who you decided you wanted to harm? See, that family's special, and you didn't treat them special. They weren't held in a special place. But it's obvious you have some problems. But we've known since 2017 you have a drinking problem that apparently causes you. But that's your decision. You got to do. Others can't come along and prevent you from committing crimes. You've got to use some self-restraint and respect of a fellow person, especially family. Please work on that.
Yes.
Okay.